Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, I recognize that there are some content creators on this platform that will make everything seem like it's five-alarm fire or it is the most important thing to ever happen. I'm not saying that this is a five-alarm fire. I am not saying this is the most important petition we've ever discussed before the United States Supreme Court. What I am going to say, though, it is very, very important. It's immensely important, especially if you live in a civilian disarmament state. And candidly, this is an issue that even affects you in a very, very red state. What am I talking about? I'm talking about sensitive places. I'm talking about the new and creative way that government can actually disarm you, not by actually taking arms from you, but just removing all the places in which you could actually defend your life. There is a massively important petition now before the United States Supreme Court that we're going to get you educated on, not only what the petition says, but why it is so immensely important to all of us. So today, let's spend a few minutes and let's talk about why this case before the Supreme Court matters to all of you. Okay, America, listen, we're not trying to clickbait you here. I want you to understand this case is really, really important. The case that we're actually talking about, and we've talked about it before, is Schoenthal v. Raoul. This is a challenge to Illinois' ban of carrying firearms on all forms of Illinois public transportation. It was appealed to the Seventh Circuit. The Seventh Circuit, shockingly, upheld the law. The suit is brought to us by our good friends over at the Firearms Policy Coalition, which means there's a link down below for you to show them some love. And I will tell you that occasionally you find these briefs where somebody develops a legal theory and you go, wow, aha, that is a really, really good argument. And that is exactly what FPC has done here. Now, the issue presented in the Schoenthal case is whether Illinois' flat ban on ordinary citizens carrying firearms on public transportation violates the Second and 14th Amendments. Okay, America, this is why this whole sensitive place dilemma needs to be addressed and right now, because it is the civilian disarmament du jour piece. You see, when that pesky little thing like the Constitution and cases like Bruin say, no, you actually have to give concealed carry licenses to your citizens, what many states went out and did is just create a large swaths of state where it doesn't matter what your license status is, you don't get to possess a firearm anywhere in that state. Sometimes they're called sensitive places, sometimes they're called gun-free zones. But the petitioners point out to what abusive ends this type of restrictions have been used for. In the wake of those decisions, the questions of what is a sensitive place has come to the fore, and the Court of Appeals opinions attempting to work it out have been muddled. The issue has taken on increased importance because after Bruin held that states must provide a way for ordinary peaceable citizens to carry firearms in public for self-defense, many of the same outlier states that previously had analogs for New York's proper cause standard for carry licenses have responded by enacting sweeping new restrictions limiting the places where licensed people can carry, sometimes explicitly admitting that the changes were spurred by the fact that the states were otherwise required to respect the Second Amendment for the first time. That is not a misstatement. Many of these states proudly called these laws, such as the Concealed Carry Improvement Act in New York, Senate Bill 2 in California. What were they called? That's right, Bruin response bills. Now, here's another important reason why this needs to be resolved, is if you take a look at the places where these states are creating new sensitive places or gun-free zones, they are actually the last places on God's green earth where you would actually want to be disarmed. And the Seventh Circuit in this case even began to acknowledge that, but could not get to the correct conclusion. As the petitioners point out here, this court has recognized that there are certain places where the need for self-defense is particularly acute. Public transportation certainly is such a place. As the Seventh Circuit panel below recognized, public transit can be extremely crowded, with commuters standing shoulder to shoulder during peak times. To make matters worse, once vehicles are in motion, escape is generally impossible, and first responders face a unique challenge in confronting an attack on crowded or confined metal tubes containing hundreds or even thousands of commuters. Yeah, it seems like an immensely dangerous place to not be able to defend your life. But as the petitioners also point out, unfortunately, Instead of protecting the Second Amendment rights of vulnerable citizens, the lower courts have been green-lighting government attempts to disarm them. That's right, because the Seventh Circuit here actually acknowledged what a dangerous place it would be to be defenseless and then yet upheld that law. And with many other issues where the courts are either unwilling or incapable of understanding some of the clear delineations of case law, they're all over the board, leading the petitioners to point out, faced with the pressing question of what constitutes a sensitive place after Bruin, the courts of appeals have demonstrated a deep confusion with the proper way to apply Bruin's analytical framework to these laws. Now, the most important part of this memorandum, and I really think that FPC knocked it out of the park here, which is this. We need a consistent historical theme. If we're going to say that we have a historical justification for any type of restriction, what is that consistent historical theme? And when it comes to sensitive places, this is what FPC claims it is, and I think it's a brilliant argument. The unifying historical justification for sensitive places is the government's provision of security to guard against unlawful use of weapons. That's right. If the place is in fact so sensitive, then government would have a history of guarding that area themselves to make sure that all people were safe in that sensitive place. As the petitioner points out, this court can and should step in to correct the confusion in the lower courts. Although the respondents below did not attempt to devise a common factor among historical sensitive places, and the analysis discussed above demonstrates that the circuit courts have similarly failed to identify a cohesive through line, there is, in fact, a single unifying feature that is shared across all legitimately sensitive places, is historically grounded as Bruin requires, and comports with the principles underlying the Second Amendment as Rahimi requires. In any true sensitive place where the government believes the presence of firearms pose unusual and unacceptable dangers, the government has historically, and continues to do so to this day, provided security to ensure that firearms are actually excluded, thereby seeking to diminish the need, in that discrete, secure location, for individual tools of self-defense. And then FPC does a fantastic job, about 4 pages going through history, going all the way back to ancient England, because hey, after all, the king's castles were guarded by armed guards as well, right? And that is the consistent historical theme, leading FPC to plead disarming people for their protection without providing security for them is the anathema to the right itself. The founders well understood that disarming people in public places without providing security to prevent unlawful use of weapons in those places would only make things worse for the assaulted and better for the assailants. And so what FPC proposes as an area that is truly a sensitive area is a historical tradition of having armed guards there, as they put it. Finally, the principle that a place may be sensitive if the government takes it upon itself to secure the location is a comprehensive principle, both providing the government with flexibility to designate those places where there really is some pre-existing vulnerability or societal tension that would be exacerbated by the presence of firearms, and adequate to explain locational restrictions wherever the government validly enacts them. The rest of the memorandum is spent attacking some of the historical analogs that the Seventh Circuit claimed to uphold Illinois' restrictions. But listen, we're going to go ahead and link the brief up down below. Like I said, this is an immensely important issue, but I think this is a really, really good brief. And kudos to FPC, because I think that the legal theory that you hashed out in this memorandum is, in fact, perfect. Okay, the case once again is Schoenthal v. Raoul. We're going to link FPC's petition down below, the link for them down below for you to show them some love. Listen, America, we're going to have to very carefully watch this case to see what happens. This case is immensely important because even if you live in the reddest of red states, you still have some gun-free zones or sensitive places that you have to deal with. All right, now listen, in the meantime, if you guys got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should not get a hold of Washington gun law by now, but if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, click on that link right there. Tell us all about it. If you want to subscribe to the monthly newsletter, there's a link in the description box to do that. And then finally, America, let's remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe. Why in the year 2024 should anybody even think about having self-defense protection? Because, 25 years ago, we would have never had this conversation. So what's different today?
Bill, we really saw a need a number of years ago when the volatility and divisiveness of our country started to change drastically. And we, by the way, are gun people protecting gun people.
Right.
We come from a significant gun background.
Right to bear, that's right. Legal protection for self-protection. Listen, good lawyers aren't cheap. Cheap lawyers aren't good. You're not truly prepared unless you have right to bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com.